Hi, this is Michael Cohen. I'm a Dallas elder law and estate planning attorney, and I'm joined by my good friend and cohort, Don Crawford Jr., who I thank for joining me on this. We had a radio show for many years, and it's always had a great dialogue. So we thought we'd just continue this with a doing by YouTube. And so here we are. We're changing with technology, and we hope that this will be enjoyable for y'all. This way, you could see us, and before when we did our radio show, you could only hear us. So this is something brand new for us, and I hope you'll bear with us if there's some changes. Today's topic is going to be on what happens if you don't have a will. What happens if you don't have a will? So many Texans don't have a will. They just assume that, okay, it's going to go to my spouse or my children, or it could be an issue. I had somebody today who said, look, my dad had a will, but they got it online, but there was a problem with the will because it was online. And said, well, you're going to have to bring one of the witnesses because the way it was done. And they just wanted to transfer the house. And the bank said, well, you're going to have to probate the will, and there's a problem with the will. And so anyway, a lot of people just don't even have a will at all. And if you do, you might be surprised by the way things go. So Texas, in effect, has a will for you. It tells you what happens, and it doesn't always go to the surviving spouse or perhaps the children. It depends on whatever the facts are. Now, there's real estate is called real property in Texas, and personal property would be things like a checking account or a savings account or stocks or some sort of vehicle or other types of personal property. So what I did was, because I thought it's easier to see than to just even hear, I did a pie chart. So let me try to get that pie chart on there on the screen for you. All right, so do you see that pie chart? There it is. Okay, so here it is. There's different things, and as you can see, if it's community property, then well, if the husband and wife bought property together from earnings by either the husband or wife, okay, it all goes to the surviving spouse if it's real estate. In fact, if it's personal property as well. However, um, if it's separate property, let's say that the husband had inherited property from a family member, then that person, the spouse, has a 1/3 life estate, and then the kids of the deceased would have a 2/3 interest, but then it all goes to his children after death under that example. As we see, as we scroll down, um, that if your property is, I don't know if you can see that or not. Here we go. Let me go up a little bit further. If it was personal property, you see it still is going. Let's see if that. Um, we said if it's separate property, it's 1/3. If it's personal property, it goes 1/3 to the spouse and 2/3 to the children. A little bit different than real estate because it's only a life estate. So let's say you had stocks, that 1/3 goes to the spouse, and then they could deal with their will or whatever the way they want on the 1/3. Whereas on the life estate, it has to go to the children.
Okay.
Now let's say that you have children that were from a different marriage. So let's say the husband had 3 children from the first marriage, and maybe even another child from the second. So the what happens if it was community property? Well, and he didn't have a will, half would go to the surviving spouse, but all the 4 children in my example would get the other half. So just if you didn't have a will, if you had a will that said everything to my spouse, that's one thing. But if you didn't have a will, then it goes half and half, half to the children. And of course, if the children die before the surviving spouse or before the deceased spouse, their children would take the share of the parent that died that was child of the deceased.
Okay.
And if it was separate property, you see it's that 1/3 life estate and 2/3 again. So the children get the majority of the share, although this spouse the surviving spouse has a right to live there for their life under the Texas Constitution. You'll notice, however, again, it's a little bit different on personal property as opposed to a life estate. It's on the separate property, it just goes automatically 1/3, whereas on the community property, it goes half and half. So it's a little bit different on personal property than on real estate, because on the real estate, it was just a life estate. It didn't vest immediately upon death. It's just the life estate that was vested. It's different on if you had no children. As you see, if the spouse, if you had separate property, of course, if it was community property all goes to the surviving spouse. But again, if you had separate property, half would go to your, if you had no children, half would go to your spouse. And if you had two parents, 1/4 would go to one parent, 1/4 would go to the other parent. If there's only one parent that survived the deceased spouse that had separate real estate, then 1/4 would go to that person's, the siblings of the deceased, and the other 1/4 would go to the parent if they had no children. And if they had no parent, if there was one parent, then one parent would get half, and the surviving spouse would get half of that separate property that was real estate.
Okay.
Sorry if I'm just kind of going through on all these different things, Don. I'm just going through the chart, but if you would think that sometimes this is different than what you might have thought. If there was only children, if there's only siblings, again, half would go to the siblings and half would go to the spouse. If it's separate real estate, let's say an inherited property. And if there's no surviving children, only then, or parents, then only then would it go all to the surviving spouse. Again, if it's community property, it all goes to the survivor. Now, let's say you're single. Well, if you have children, it goes equally to your children. And if one of those children dies, it goes to that child's children, that person shares. So if there's 3 kids and one of them predeceased, then that 1/3 share would go to that person's, let's say, 2 children, or whatever, however many children there were. If there's no children, then half of the, whether it's real or personal property, half would go to the mom and half would go to the dad. And if there's one parent and you have siblings, half go to your siblings and half go to your parent. If there are no children or siblings, or the survivors of your siblings or children, then it goes all to the parent. And if you have no children or parents and only siblings, then it gets divided equally. Of course, if one of those siblings dies, then it goes to their children. And if there's no children, siblings, it's parents, then it goes half to your moms down the line and half to your dads down the line. It's called two moieties. So it kind of gets into complications. And so often when people have real estate, for example, this is where they're really the issue is a lot of times. And that's why to try to make things easier, because so many people didn't have wills, that people had transfer on death deeds. So they wanted to make it, because some people say, oh, I can't afford to do a will, which seems so silly, but a lot of people feel that way, and a lot of people maybe can't afford. So they wanted to make it easier for people to plan. So there was title nightmares for title companies when you sell properties, because then one child died or somebody died, and then that person had 5 children, and it got all, and they go on for generations. And you could never sell property because there were so many people to get involved. And so you didn't, because you have to go by the laws of intestacy. And what happens then? How do you determine all this? Well, often you have to have an heirship determination, which means going to court and seeing if there's somebody who could represent as an administrator. And if they don't agree, then there's a dependent administration, and getting everybody to get notice. And it's a whole rigmarole, as I used to say. So it gets to be very complicated. So the bottom line is that you should try to plan to have different, do something. Now, some people might say have beneficiary designations of accounts, or even on real estate, like the transfer on death deed or ladybird deeds that we sometimes do, which avoid probate. But then there's lots of different issues regarding that that would have to be looked at before you do it. And even on our last legislative session, even people with mobile homes, if they just own the home itself, it was passed where there could be a beneficiary designation. And on a car, similarly, you can have a beneficiary designation just like you could on a bank account. But again, you have to look at who the beneficiaries are. Do they have creditors? Do they have bad marriages? Do they have an addiction? Are they disabled? Are they on public benefits? Lots of different issues. So it's not just avoidance of probate. Well, I don't know. I know this, I've kind of just rambled on here, but the chart is available on our website, which is dallaselderlawyer.com, dallaselderlawyer.com. And if people have questions on that, we often say just come to our next workshop. Our next workshop is on September 16th at 10 o'clock a.m.
More time, Michael. One more time, September 13th.
Oh, thank you. Our next workshop is September 13th at 10 o'clock. It's in person, and all you have to do to sign up for that free estate planning essentials workshop is call 214-720-0102 or sign up online at dallaselderlawyer.com. That's dallaselderlawyer.com. Don, I didn't give you much time I just kind of rambled on there. Did you have any questions on the?
No questions, just thoughts, and that is that, as you said at the beginning of the program, we presume so much, and that if my spouse dies, then it all just goes to me, or if I die, everything goes to my spouse, and that's reckless thinking. There's no presuming anything the way time and issues and policies and decisions are made so quickly. So we just have to simply keep up with the times as much as you possibly can, and that means to attend Michael's workshop. But if you do that, just bear in mind too that these pie charts are complicated. They're deep, and these are the solutions. Imagine, as Mike said, the nightmares that were created before these solutions came up. And I was going to ask you, Michael, while you were talking, when did they come up with this? When did they come up with these pie charts and decisions?
Well, it's actually changed over time is a really good question, because in the early 90s, like before 1992 or 93, the children, it didn't all go to the spouse originally. It was shared between, even if it was community property, I believe there was September 1st, 1993, I believe it changed, and it had a different rules on real estate and personal property probably as well. So if somebody died way back then, we would have to look at and they never did a will, we'd have to look at the laws back then. So things have changed over time. But, this has probably been this way since probably Texas became a state.
Yeah.
So it's been a while. So you just go, and because even the Texas Constitution has a life estate for the surviving spouse, even if it's separate property. So that was, 1840s or whatever. So it's been a while.
It's been a while. It's a long time ago, but this is what the legislators, the people we voted for, decided was best. So we live with that. We don't complain. I mean, maybe we will, but this is the facts. This is what we have to live with. So attend Michael's next workshop to make sure you know them, because they change all the time. And you saw how deep this is just by looking at those pie charts. Well, if this and this and this and this, but what about this, siblings, and what about spouses, and what about parents? Goodness gracious. And that's just one state. Imagine the other 50 states or whatever the number is. It's complicated. So attend Michael's next workshop, which is Saturday, September the 13th at 10 o'clock. It's in person, it's live, and it's interactive, and it's very beneficial. So I highly recommend, if not admonish, people to attend that.
I'm going to just add one more thing. If y'all like that pie chart, and if you like this, since we're brand new at doing this, just push the like button to say you like this, and so we'll know if I should be doing other charts or other different shows at some point. So I appreciate all those who joined us today, and I hope that if you do have questions, come to our next workshop. And even if you hear this recording after that, there's always a workshop every month. So that 214-720-0102 number can reserve your spot, or you could sign them up online at dallaselderlawyer.com. Thank you all. Appreciate it. And I'm going to stop this here.
Thank you, Mike.